Hi everyone, and welcome back to my channel. If you haven't been here before, my name is Kimberly and I am an attorney here in Memphis, Tennessee. I give all sorts of video tips and some information to parents and people who are going through the divorce process. Today's video is a little different because it's very specific to people who are in a situation where they are going through a step-parent child custody battle. And so if that is you, if you are someone who is either the biological parent of the child, or if you are someone who is trying to get some parenting time with your child, then this video is for you. There has been some very significant changes to step-parent visitation, and we're going to go over them all today. But let's start out with the actual code, which is Tennessee Code Annotated 36-6-303. Maybe you are in a situation where you've been married for several years and you have become very emotionally attached to a child that is not your biological child. Maybe you've even had a child with the person that you're married to, and now you have siblings that are actually half siblings, and you would like to have some parenting time with both of them where both of them are coming back and forth to your new home after you are divorced. You may also be in a situation where you are trying to prevent that from happening. So we're going to go over the law and how it has changed, and it's definitely slanting toward the benefit of the biological parent and not the step-parent. The law has gotten quite a lengthy overhaul, and so if this is something that affects you, I would encourage you to stick with it and listen to the very end of the video, because I think it has a lot of useful information that's going to help you in your case. So let's start off with the very first sentence in Section 1, subsection A, which is, in extraordinary cases, comma, the court is authorized to order step-parent visitation, and then it's going to go through the circumstances. So we already know that this is not going to be easy. You're going to have to start off by proving that this is an extraordinary case if the biological parent is contesting any sort of step-parent visitation or wants to prevent step-parent visitation. Let's talk about how we even get this process started. So under the new statute, it says if a parent or former step-parent presents a petition or a motion in a pending case to which the step-parent is a party. So we know that we will either need to file a petition if it's brand new, or if there's an existing case, we can file a motion in the pending case. Next, the new statute is going to tell us who has jurisdiction to hear these petitions or motions. First of all, the circuit court, then the chancery court, the general sessions court, and a court with domestic relations jurisdiction, or the juvenile court of the county in which the stepchild or the former stepchild resides. We have to file a petition where the child is living, and pretty much all of the courts that we deal with would have jurisdiction. The next part of the statute gives the court some guidance. So it says, the court shall set the matter for hearing if the visitation is opposed by the parent, meaning the biological parent or the custodian, or if the petitioner's visitation has been severely reduced by the parent or custodian, and any of the following circumstances exist. So we'll get to the circumstances in just a second. Where I have seen this played out in real life, in real cases, is that possibly a biological parent has died, and maybe the grandparents are the custodians, and they don't want to allow a step-parent to continue to see the child for some reason. That could be one circumstance where the statute could play out. Another way that this could play out is what we were talking about before, which is when there is a divorce case pending and the biological parent does not want the step-parent to have any further contact with the child. It is generally assumed by the court that the biological parent has the best interest of the child in mind and knows who is the most suitable to be around their child. However, we know that in real life, when emotions and divorce come into play, people don't always have the best interest of their child or children in mind. Now that we've got a couple of scenarios in place, let's take a look at the circumstances directly from the statute. I've given these to you, at least the first four, in a bullet point format. So the first circumstance is the parent of the child to whom the petitioner was married is deceased. So that's kind of one of the circumstances that we were talking about earlier, where maybe a grandparent has the child or children and the step-parent is trying to get some official parenting time with that child. Circumstance number 2, the child's parent and the petitioner are divorced or in the process of seeking a divorce. That goes back to the other scenario that we were talking about, where the parents are in the process of getting divorced and mom or dad, that's the bio parent, does not want the child to be around the former step-parent. Circumstance number 3, the whereabouts of the child's parent to whom the petitioner is married are unknown. So we have this missing bio parent. I have had a couple of cases like that over the years where mom was having some sort of mental breakdown and she was on drugs and we could never find her. It was hard to even get her served. And so that could be a scenario where you are trying to get some legal rights for this step-parent and a third party could be stepping in, like a grandparent or an aunt who is a biological relation to the child, and trying to remove them from the step-parent. The fourth and final circumstance on this slide, because there are 2 more after this, is that the court of another state has ordered the visitation between the child and the step-parent. It could be that the parties were divorced in another state, or they have recently moved here from another state where the court had jurisdiction. So those are the first 4 scenarios. Let's move on to the next slide. The 5th circumstance is found in subsection E of the statute, and it's rather lengthy and a little bit complicated, so I tried to break it down bullet by bullet for you on one slide. So here we go. The child and petitioner must have maintained a significant relationship for a substantial period of time. It doesn't really tell us what substantial is. That's something we're going to have to argue. So a significant relationship for a substantial period of time before the severance or severe reduction of contact. So it can be a complete cutoff or just a severe reduction. Again, it doesn't tell us a percentage or how much a severe reduction in contact would be. Also, that the contact was severed or severely reduced by the parent or custodian of the child for reasons other than abuse or the presence of a danger to the child of substantial mental, emotional, or physical harm. Finally, the severance or severe reduction of this contact has to be likely to cause substantial, again, there's that word that we're going to have to come up with some arguments on or wait for some new case law to come out, that this contact is likely to cause substantial mental, emotional, or physical harm to the child. So again, significant relationship for a substantial period of time where contact has been either completely severed or severely reduced for reasons that are not abuse, and that it's likely to cause mental, emotional, or physical harm to the child. Let's move on to the last slide in the circumstances under subsection 1, which will be subsection F. The final circumstance can be found in Section 1, subsection F, and it tells us the following: that there has been an unreasonable denial of visitation by a parent or a custodian, and the denial has caused the child severe mental, emotional, or physical harm. So again, unreasonable denial of parenting time leading to severe harm. Well, there you have it. Those are the first 6 circumstances that the court is considering under subsection 1. Thank you for watching part 1 of our series. The next video in the series is going to talk about the 12 factors that the court considers. So if you've already watched this video, you definitely want to watch the next video about the 12 factors. We really appreciate you tuning in today. If you liked this video, please give it a thumbs up. And if you really liked it, you can subscribe down below, and be sure to comment if there's any other topics in the legal realm in Tennessee that you would like some advice on.